Wish you all a very happy Diwali season. Compliments of this Diwali season. Okay. Today we decided to speak on the procedure for commencement of the civil trial. Okay. How the trial takes place in various civil courts. So all the civil courts in the city of Bombay, you have the original site of the Bombay High Court, city civil court, small causes court, cooperative court, elsewhere, civil district court, civil judge, senior division, junior division. So they all follow the same procedures contemplated under the provisions of the Code of Civil Procedure as well as the Evidence Act, now the BSA, which is applicable to all the courts. Because Evidence Act applies to both the civil court and criminal court. Now today we are dealing in this lecture that how the trial takes place in the civil court. So you know that here the pleadings which the parties file, normally the plain written statement, counterclaim, set off, the notices, interlocutory application, and affidavits, they are technically not evidence. Prima facie, the court may consider for the purposes of certain orders, but for proving your right title interests, for passing of a decree before by the court, by a civil court, you are required to lead full evidence before the court. So evidence is of various type under the Evidence Act. There is the primary evidence, which are original documents. Then there's a secondary evidence, which is a Xerox copies, certified copies, and oral accounts of the copies. Then there is also sometimes a hearsay evidence, which is also normally not evidence. But under the Evidence Act, oral evidence is admissible under Section 59 of the Evidence Act. Now we will deal with it, how this evidence, how the plaint is to be proved, written statement is to be proved, counterclaim, set off, and various applications which you prove, and affidavits, documents, list of documents, and interrogatories in a civil court, how they are proved will do. Now let us, for example, now, yes, a suit has been filed by you, by your client in a civil court for declaration of legal right, maybe a suit for specific performance, or maybe a suit for declaration of your status as a owner of the property, a suit for a declaration that defendant is a rank trespasser. Whatever may be the suits, I'm not quoting, suits of various nature. So all of you know that a civil law is set into motion by the presentation of a document called plaint. Everybody knows that here. So once the plaint is ready, that is your document, which is under Order 4, read with Section Order 7 of the Code of Civil Procedure, read with Order 6 pleadings. Then once the plaint is filed, within 1 month, the defendant has to file the written statement. Now, one of the important requirement of the plaint is that here, along with the plaint, the plaintiff is required to produce all the document which he seeks to rely upon in the trial, which is a mandate under the provisions of Order 7, Rule 14 of the Code of Civil Procedure. Please note that here. Plaintiff is enjoined with a duty to produce the document so that the defendant is not taken by surprise. The only those documents which he can withhold are the documents of the defendant, which you can use it for cross-examination of the defendant for contradiction purposes under Section 145 of the Evidence Act, which I will explain to you. So these are the documents the plaintiff can withhold, need not supply in the list under Order 7, Rule 14 CPC. In case he does not supply these documents to the other side along with the plaint, normally the court does not permit you to lead evidence at the stage of evidence of this document unless permission of the court is specifically taken under Order 11, Rule 13. You have a right to produce the document. Courts are normally very liberal and allow the application, I will tell you. So the plaintiff has produced the set of his document under Order 7, Rule 14. Okay. Then the defendant will deny your contention, obviously, taking up various pleas that the suit is not maintainable, the suit is barred by limitation, the suit is suffers from the vice of res judicata, that the leave under Order 23, Rule 3 CPC is not taken, then leave under Order 1, Rule 8, representative capacity is not taken. We'll deal with it, how it is to be done. So the written statement is filed. Along with the written statement, the defendant is enjoined with a duty under Order 8, Rule 1A to disclose the documents which the defendant proposes to produce before the court. These are the documents which are akin to the document of the plaintiff under Order 7, Rule 14, so which the defendant is bound and liable to produce under Order 8, Rule 1A CPC. But the defendant can withhold those documents and need not disclose at this stage to the plaintiff documents which are the documents of the plaintiff, which can be used for the purpose of cross-examination for impeaching the credibility of the plaintiff, the other side, under the provisions of Section 145 and 146 of the Evidence Act. And I will tell you how the role of the Evidence Act come into play. So they are still at the stage of marshalling facts, the pleadings, and the documents. Now, the moment your plain and written statement is completed, in the civil court, the next procedure will come into play under the provisions of Order 10. Order 10 CPC plays a very pivotal role, under which the court has a right to examine the plaintiff or defendant. Please note that here, to decide whether the court may ask you a question, are you accepting any part of the claim or full claim? I can pass a decree. If you are refusing it, please let me know. So here examination of the parties is done, is a formal examination under Order 10. Please note that normally these provisions of Order 10 are normally not invoked by judges in ordinary courts of nature. I have not seen, at least in the city of Bombay, where judges are invoke the provisions of Order 10 before framing of the issues, after framing, before the issues, for determining what is the real controversy between the parties. Now, uske baad, the next step is Order 10 Rule 1A mandates that compulsorily the trial court must send the parties for arbitration, conciliation, mediation, lok adalat, pursuant to the provisions of Section 86 of the Code of Civil Procedure. See that the Code of Civil Procedure is a very old act of the 1806, whose zamane se arbitration was containing. See, the mandate of the law, the law mandate that the parties should rather settle the matter amicably rather than litigating it. So you see that your order 10A, 10A के हिसाब से under Order 10A, Rule 1A, mandate that here the judge should direct the parties to discover, to explore the possibilities for a settlement and send the matter for arbitration. There is normally a next judge in the same court who will be dealing with arbitration, conciliation, mediation, the lok adalat. All of you know that here is a lok adalat, so that the matter can be amicably settled. If the parties agree, decree can be drawn up and it can be sent for execution. The parties normally don't agree at this stage for A reason, B reason, C reason. Then if the judge is of the opinion that here the advocate has not been able to satisfy to the court what are the questions to be determined by the court, at this stage under Order 10, the court will say, keep the matter for framing of the issues. Please note that framing of the issues will take place under Order 14. Now, prior to the framing of the issues, before we invoke Order 14, there are pre-trial requirements which, as a young lawyer or a student, you should remember. The pre-trial requirement are, one, the pleadings are completed, or even before, one, the written statement ho chuka hai, counterclaim is filed. There is also a written statement to counterclaim or set off. Then it is advisable the parties take inspection of their respective documents under Order 11, Rule 1. Inspection of each other document. So you are not taken by surprise exactly what the case is. Then you have a right to exchange interrogatories. A question answer पूछेंगे आप. The defendant will take up the plea that there is no breach of contract as alleged by the plaintiff. I was not in Bombay. I was in New York at the time. You may ask him in question interrogatories. You went to New York in which year? Which date? Please give the details of your visa, your passport number. Where did you stay for longer time? So these are the interrogatories which you may ask to the defendant or plaintiff in each other parties. that is covered under Order 11, Rule 1, 2, 3, 4. देख लीजिए आप. Interrogatories under the CPC, there is a special form number 1 in Appendix 6. You check, make a mental note of it. You can go home and study later on. Order 11, Order 1, Rule 1, 2, 3, and 4 to be seen for the purpose of interrogatories. How questions are framed by each party for the other party to ask, because this will minimize the burden of a trial and the court. So these are normally mentioned in form number 1 in Appendix C. Appendix C will come into play after all the sections are over. In the CPC, of course, you can lay your hand easily. Then, if the other side refuses to answer the interrogatories, the court will draw adverse inferences under the provisions of Evidence Act 114G of the Evidence Act, which will come to know today. Then, uske baad, interrogatories are answered. If I suppose the plaintiff is asking questions to the defendant, interrogatories, please inform the court as to when at the time of the proposed contract, termination of the contract, where were you? You were under obligation to pay so and so amount. Why did you not pay? He say, your check has been bounced. Give the particulars of the bank account, details of the account. Then the answers can be given in form number 3 in Appendix C. Form number 3 of the Appendix C के अंदर वो देख सकते हैं आप. Then Order 14, Order 11, Rule 14 deals with the power of the court to pass orders with regard to documents, because some of the documents may not have been produced by the party under the provisions of Order 7, Rule 14, under Order 8, Rule 1A. Then the plaintiff or defendant can make an application to the court under Order 11, Rule 13, that I may be permitted to produce the documents which could not be traced out earlier. This has come to my attention recently, that you file a list of documents. So there's a list of documents prepared. Affidavit as to documents are prepared by the parties here, that can be filed under the provisions of Order 11, Rule 13 CPC. Please note that. The court normally grants permission. Then उससे पहले there is one more, that is Order 11 का role हो गया. Then Order 12 का role also will come. There are admissions. There are certain pleadings के अंदर your suit is filed for a recovery of a sum of rupees 10 crore. The defendant say, no, that I am liable to pay only 5 crore. Then the decree can be passed on admission under Order 12. So Order 12 CPC deals with admission. Notice can be given by the party for recording the admissions. Now that form is also the admissions के लिए, or form number 10 and 11 in Appendix C. Appendix C check करेंगे आप CPC के अंदर. You have to follow this procedure, because the moment you have to mention, I am hereby giving you this notice for admission as per the provisions of Order 12 and form number 12 in Summer CNC. You must remember this. And if the parties don't, because there is also a provision under the Indian Evidence Act relating to admission from section 17 to 21, that you go through that here, how admissions are binding upon the parties, their agents and representatives. That is, at the time of the evidence, you can cover it. Now, for the purpose of seeking admissions, this is a pre-trial arrangement. You can give a notice to the other side in form number 10 and 11 in Appendix C. Admissions before the examination chief, cross-examination start, this should be done. Please note that here. Then, despite notice of protection, if the other party does not produce the documents, then of course you have a right to request the court to draw adverse inference under the provisions of section 114G of the Indian Evidence Act. Will deal with it here. Then before the commencement of the trial, then affidavit as to document under Order 11 Rule 13 is to be filed, because you have to file. That is filed in form number 5 in Appendix C. वो देख लीजिए आप CPC के अंदर. Mean you have to mention in by way of affidavit, I, the plaintiff number so and so, do hereby solemnly affirm and state that I have in my possession the following document A, B, C, D. I hereby refuse to produce so and so XYZ document because they are privileged documents. The document number 3 is a document which is not in my possession, a sale deed in the possession of the defendant. I have a copy. Disclose it here, because a sale deed copy is not a primary evidence. It is only it is a secondary evidence under section 63 and 65 of the Evidence Act. And how do you prove the sale deed which is not in your possession, which is in the possession of the defendant? I will tell you. You have to give a notice to the other side under section 66 of the Evidence Act, placing on record that here, look, the matter is now set for trial, filing evidence in the matter. I have filed my examination chief along with the list of documents. I have produced the sale deed copy, the original of which is in your possession. I hereby request you to bring the original document on the date of the trial on so and so date until the witness is discharged. और सेक्शन 66 की नोटिस देनी पड़ेगी आपको, which you should bear in mind. That is for proving a document which is a secondary evidence. Secondary evidence cannot be led unless you establish where is the original document. Primary evidence kahan pe hai? Under section 62 of the Evidence Act, it tells you that the parties should be directed to first lead the primary evidence. If there is no primary evidence, doesn't mean that the end of the court for you. You have a right to tell the court, I have secondary evidence. There are Xerox copies. There are ordinary copies. I have the oral contents of a document which were recorded by the typist, stenographer, who knows the matter, in whose presence my grandfather dictated the will, his will, to the stenographer or a junior advocate who took down. So these are the oral contents of the primary evidence can also become they become secondary evidence which are admissible provided a foundation is laid. You see that for the section 63 of the Evidence Act. So the list of document file kiya aapne under order 11 rule 6 under order 11 rule 13 and list of document file kiye. Then when these documents are filed, normally both the parties file it here, both the plaintiff and defendant file it here. Then the next stage will be order 14 of the Code of Civil Procedure, that is a stage for framing of the issues. Issues mean what are the contentious points before the court to be tried. The plaintiff has filed a suit for declaration that he is the owner of the property, and for a declaration that the defendant is a rank trespasser. He does not have a right title interest in the property, liable to be evicted. Our defendant का issue written statement में ये point लिया गया, the suit is barred by limitation. Number 1. Number 2, he will take up the plea that the plaintiff father also had filed a similar suit on the same ground way back in the year 2015 or 10. That suit came to be dismissed by the court. So there is the present suit suffered from the vice of res judicata under section 11 of the Code of Civil Procedure. That is one of the second issue. Then you may take up the plea that here the earlier suit which was filed on the same cause of action was withdrawn by the plaintiff without the leave of the court, and the cause of action in the second suit is same. Order 23 rule 123 mandates that here when you have filed a suit earlier against the defendant on a particular cause of action, namely a suit for specific performance of a contract, or a suit for declaration that he is a trespasser, suit for a declaration that he is a tenant at sufferance, whatever may be. If that suit having been dismissed earlier for A reason, B reason, you cannot file a second suit, or if you have withdrawn the suit. Suppose you had withdrawn the suit, parties have by consent settled withdrawn without the leave of the court under order 23 rule 3, then second suit is barred. Please note that whenever your clients say that hamara suit settled ho gaya hai, withdraw karo instruction, try to make an application to the court that liberty may be given to you to file the suit on the same cause of action subsequently. Because tomorrow the consent terms may be filed in the suit, that consent terms are not complied with the defendant. You have a right to file a second suit. Second suit cannot be filed by you unless you have sought permission of the court, liberty to file the suit on the same cause of action. On a different cause of action, you don't require permission. If the suit is sought to be filed, suppose if you are a landlord, filed a suit against a tenant on the ground that subletting has taken place, nuisance has taken place, and the suit is withdrawn by filing consent terms. After 2 years, you cannot file a second suit on the same ground of subletting and nuisance unless you had previously sought the permission of the court under Order 23, Rule 3 for filing the second suit on the same cause of action. So the defendant will take up this plea here. So I'm just imagining the various contention, the possible contention which the defendant may raise in his written statement. Then the defendant will take up the plea that here the court has no jurisdiction to entertain and try the present suit. So under Order 14 of the Code of Civil Procedure, the court will frame issues. Issues are two types: issues of facts and issues of law. They are the material proposition from the pleadings relating to law points or your facts. Now, Order 14, Rule 3 says that issues can be framed, number one, from the plain written statement and the document submitted by the parties, also the interrogatories. The interrogatories which are referred to under Order 11, Rule 1, 2, 3, and 4 may discuss here. And if some of the interrogatories are not answered correctly, you may inform the Honorable Court the issue required to be framed on this point. So bear in mind the provisions of Order 14, Rule 3. Then Order 14, Rule 2 mandates that here the court must pronounce judgment on all issues simultaneously. Order 14, Rule 2, Sub-Rule 2 says that here on preliminary issues of law, the court may give judgment and decide those issues separately without even leading evidence to the parties so decide, or with leading evidence. Issue of law can be decided as a preliminary issue. Namely, for example, the court has no jurisdiction to entertain and try the present suit. The cause of action accrued not in the city of Mumbai, in Calcutta or Madras. If the suit is filed against a trespasser, against a trespasser in respect of a premises which is not situated in the city of Mumbai, or leave of the court has not been taken under clause 12 of the latest patent of the Bombay, isn't it? That the defendant did not reside here. So, if a suit is filed, in a court which inherently lacks jurisdiction, then you may say that here the issue of jurisdiction goes to the root of the matter. It may be tried as a preliminary issue. Or the suit is barred by limitation, because under the Limitation Act, suit should be filed within a particular limitation. Suit for recovery of property, contractual suit 3 years time. Suit for recovery of property 12 years time. Suit for mortgages 30 years time. So various times I've given here, all of you know that. Section 27 of the Indian Evidence Act says, if the suit is not brought within the period of limitation, the rights of the plaintiffs are extinguished. So you can take up the plea here, my lord. The suit frame is by the plaintiff is after 12 years. So he is filing the suit on the ground that I am a trespasser. Under Article 65 of the Limitation Act, it should have been filed within 12 years. Now the suit is filed after 15, 20 years. The issue be framed on that point and may be decided. The court can decide it. Court has a power to decide under Order 14, Rule 2(2)(a). Formerly in Maharashtra, we used to have a section called 9A, which has been now deleted. Section 9A, preliminary issue of jurisdiction, that can be raised by the defendant anytime, even before the grant of interim or interim relief and before the filing of the written statement. Now that has now been deleted because a lot of time used to be consumed. People used to wait a lot of time, and appeal provision was there, and proceedings were unduly protracted. The Supreme Court directed the legislature to delete that section, and it has been rightly deleted. Okay. So the stage of framing of the issues is very important. These issues are framed with a view to enable parties to lead evidence. Now, issues, for example, in a suit for declaration, the court will say that, does the plaintiff prove that he is entitled to the ownership property, or does the plaintiff prove that defendant is a rank trespasser? Does the plaintiff prove that the defendant has no right title interest? Does the plaintiff is entitled to mean profit? These are the plaintiff's main. Okay. The defendant has raised the issue that the defendant has become owner by adverse possession. In the written statement, you likhega, I am in possession for more than 12 years in a hostile manner. I become owner by adverse possession. So, does the defendant prove that he has become owner by adverse possession? Then the defendant will raise the plea that the suit is barred by limitation. Does the defendant prove that the suit is barred by limitation? Then the defendant will take up the plea that the court has no jurisdiction. Does the defendant prove that the court has no jurisdiction? So these are the issues which are normally framed under the provisions of Order 14, Rule 123. Now, courts are normally flexible even at the stage of judgment and decree. Before judgment is passed, issues can be amended. Under Order 14, Rule 5 CPC, there is application made by the court to the court that additional issues be framed, because during the pendency of the suit, the property has been transferred to XYZ. There is a pendent-like transfer under Section 52 of the Transfer of Property Act. So the plaintiff has sold the property, or defendant has sold the property and brought in, inducted XYZ. So when they are brought on record, then additional issues may come. So he is the assignee of the defendant or plaintiff. He is the assignee entitled to defend the suit, or the assignee entitled to continue the suit. The court may frame those kind of issues. That is, for that purpose, you have Order 14, Rule 5 of the Code of Civil Procedure. Please note that they are similar to charges under the CRPC. These issues. Once the issues are framed, uske baad the next stage comes here. Normally parties should be directed to file the list of witnesses. Please note that Order 16, Rule 1 CPC tells you, because whom are you going to examine, plaintiff or defendant? Under the provisions of CPC, either the plaintiff or defendant can begin the suit first. And I will tell you when the plaintiff has to begin and when the defendant has to begin. It is not mandatory that plaintiff also only has to examine the witnesses first and not the defendant. It may change the position. Under what circumstances, I will tell you here. So you file the list of witnesses after the framing, or before, even sometimes judges say that before the framing of the issues, you file the witnesses. There is no barrier. Sometimes, even after the framing of the issues, you have not filed the list of witnesses. If the witnesses are very important, you have a right to make application to the court, issue witness summons under Order 16 that I need to examine. For example, you want to prove that the defendant is not residing in the premises which is lying locked and unused. So you will discover that here electricity meter is not functioning. And you will also get the record that here defendant was not residing and he has not voted for the election for at least 5 to 10 years. आपने election record भी निकाल लिए. समझे ना आप? Then you have a right to, election record can be public document under Section 74 of the Evidence Act. You need not issue witness summon to the Election Commission of India. If you obtain certified copy, the court will normally permit the examine. But so far as electricity bills are concerned or ration card is concerned, I'm afraid the court may not accept this document unless you produce those documents, issue witness summon to the officer of the BST department, or Reliance, which is now having energy supply units in the city of Mumbai. They are companies. You have to issue witness summons. Be pleased to issue witness summons to Reliance Energy or the BSNL, BST to produce the electricity meters in respect of following premises of Mr. So and so and to give evidence. वो प्रोड्यूस करेंगे आप कोर्ट में, witness will come. That witness, when he bring those documents, or he'll bring printouts from the computer. Nowadays everything is computerized. Huh? Computerized documents are not admissible per se directly. If the original documents which were produced by officers signed by him can be taken as a primary evidence. Computerized document you had to obtain a certificate from the officer who took out the copies from his computer under section 65B following Supreme Court judgment in the case of Arjun Panditrao Khotkar's case. Remember this very well-known case? Arjun Panditrao Khotkar's case, section 65B of the Evidence Act. Now it is section 63 of the BSA. Okay? सेक्शनों में ज्यादा कोई ये चेंजेस नहीं है, मोरल सेम. सो उसके अंदर दैट सर्टिफिकेट, suppose if you are taken photograph of a incident, you have done recording of the defendant's voice, they are containing admission, and you had to file your affidavit and your pen drive along with your certificate under section 65B that the electronic device belongs to you. It bears so and so number. It has been purchased by you from so and so, and it has been taken by you, and you are the author of this document. It will be admitted. Similarly, the officer who comes from the BSNL or Reliance also file the affidavit, placing on record, I so and so is the authorized officer of the BST, BSNL, or Reliance Energy. I have been directed to produce the electricity documents of this particular meter. This concerns the defendant. I say that these documents have been generated from the computer maintained by our office in the regular course of business. Under the Evidence Act, any activity which is done in the regular course of business is admissible. These are the serial number you have to give. This is the computer number, so and so, so and so. A certificate of the officer under the Information Technology Act, you please also carry with you Information Technology Act. Uske andar the officer gives certificate. Oh, certificate should be produced. Then it will become admissible under section 65B as a secondary evidence, not as a primary evidence. Primary evidence is the original, and the copy which has been taken out is a secondary evidence. So you produce it here. In the list of documents में produce कर दिया आपने. Then the next stage will be for filing your evidence. Evidence of the party who proposes to lead evidence. Order 18 of the Code of Civil Procedure, Order 18, Rule 1, tells you right to begin. Who should begin the proceeding? The plaintiff or defendant. Now here the plaintiff has asserted that he is the owner of the property, defendant is a ranked trespasser liable to be evicted. So under the Evidence Act, section 101, 102, 103, the burden is upon the plaintiff for this purpose. Now this burden can only shift upon the defendant. Agar defendant kaha, the suit is barred by limitation. The court has no jurisdiction. The earlier suit has been dismissed, resulting in res judicata. The earlier suit has been withdrawn without obtaining leave under Order 22, Rule 3. Or it is a representative suit under Order 1, Rule 8, which has been filed without the leave of the court. So these are the legal points which the court will permit the suit to be tried on the basis of preliminary issues. So you may tell the court, there is no need to waste a long, lengthy trial. Civil courts are very lengthy. The suit can be disposed of on the point of jurisdiction. This honorable court does not have jurisdiction to entertain and try the present suit. Isn't it? You may take up the plea that the suit is filed by you in the Bombay High Court original suit for a declaration that defendant is a ranked trespasser. Defendant will take up the plea that, no, I am not a trespasser. My grandfather came as a licensee under a leave-on license agreement in the year 1973, which was subsisting. He became a deemed tenant. You may take up the plea. So, only the court of small causes court can try the present suit and not the small causes and not the honorable high court or a civil court. So the issue relating to jurisdiction goes to the root of the matter and may be tried as a preliminary issue under Order 14 Rule 22 CPC. समझे ना आप? As a alert. Then in that event, if the court permits it, then the burden will shift upon the defendant. Right to begin, defendant शुरू करेगा. So he will file his examination chief, which is normally filed under Order 18, Rule 4 CPC. Formally, under the in a criminal trial, unless it is a 138, you are not permitted to lead evidence by affidavits, unless formal witnesses. Even CPC के अंदर prior to 202, there was no provision to file affidavit as evidence. Parties must go into the box. Advocate will used to ask question in interrogative form. आप बताइए कौन है? Why you have filed the suit? Who is the defendant? Do you know him? What is the cause of action? Interrogative question, not leading question. Now the law says that here calling a witness to the court and leading examination chief is consuming substantial time. So the legislature amended the CPC in incorporating Order 18 Rule 4 CPC, permitting the parties to lead examination chief by affidavits. Normally affidavits are not evidence, but here specifically made evidence. CPC may you also contain, there is a provision for filing affidavit under Order 19. Any facts are required to be proved by leading evidence, by affidavits. But those affidavits are normally not evidence. Affidavits under Order 19 are not evidence unless the person who has deposed, made the affidavit, is asked to summon as a witness and take oath and identify his signature. Now, there is a departure under Order 18 Rule 4 CPC for the purpose of examination chief. Parties need not be directly. There are two options given: file examination chief, affidavit file karo aap, and send the matter for cross examination. Either to the court commissioner. The court normally will appoint a high court, city civil. High court normally doesn't have time. Even the Supreme Court, when deciding matter under the original jurisdiction under Article 131 of the Constitution of India, they will say that let the examination chief go on before the court commissioners. Court commissioners are appointed under Section 75 and under Order 26, Rule 1, 2 of the Code of Civil Procedure. Cross-examination will take place before commissioner, but normally in other civil court, district court, city civil, small causes court, cooperative court, judges themselves, they try and they take up the matters and dispose it of. Or the parties may, by consent, if the witness is unable to come or not keeping well, he may make an application that I may be examined on commission. That is by way of examination chief. At the moment, so the analogous provision under the Evidence Act for examination chief is Section 137 of the Evidence Act. Okay. I will ask Sayali to give the analogous section in BSA. She'll give you. Section 137 of the Indian Evidence Act. BSA aa gaya. More or less sections are same. The order? 142 of the BSA. Adhiniyam mein. Abhi dekh lijiye aap. The language is same. Now language is not disturbed. Only the sections have been disoriented or maybe oriented. I cannot say. Okay. So you remember this Order 18 Rule 4 for filing your examination chief should be read along with the provisions of Section 137 of the Evidence Act. So if the plaintiff or defendant is going in the box, you need not put him in the box. But normally how it starts here, examination chief, I so and so the plaintiff do hereby state on solemn affirmation as under. I am filing the present application in examination chief pursuant to the provisions of Order 18 Rule 4 CPC. Don't lift the provisions of entire plain or written statement. Evidence should contain not exactly whatever is stated as pleadings in the plain or written statement. Proof you have to mention. You may mention, for example, the present suit is being filed for a declaration that the defendant has committed flagrant violation of the agreement of sale. Breaches of the agreement of sale, he failed to give you a flat. I purchased the flat in question from the defendant, who is a developer and builder, pursuant to agreement of sale dated 1st January 2000. I paid the full consideration. I hereby produce the original registered document which is marked serial number 1 in the list of document. See that how you are connecting your evidence. This document contains the signature of the plaintiff, the defendant, and the witnesses. I have paid consideration to the defendant. The contents are correct. It's a registered document. A registered document, a presumption arises, it's a valid document. So the court will normally exhibit this document. So that is how you connect your document in the plaint. But whereas when you are mentioning in the plaint में जा रहे हैं यहाँ पे, at the time of the filing of the suit, here to annex mark exhibit A is the copy of the plaint. उतना ही हो गया. But at the time of the protection of the evidence, you mention that here, I am the plaintiff, submit that he has purchased the suit property, namely flat number so and so, from the defendant, pursuant to the agreement of sale dated so and so, which is serial number 1 in the list of document. This is signed by the plaintiff and defendant, signed by the witnesses, consideration, which facts you normally don't mention in the plaint. Evidence में आपको detail देना पड़ेगा. Unless you give the details, your evidence will not be admissible. So bear in mind, this will be attracted under section 62 of the Evidence Act, is a primary evidence. Read with section 60 and 62. Huh? Done with the time? Question answer. Then I'm, yeah.
If you have something, you can continue.
Yes, yeah. Then suppose in case you have the document, I think that this topic will continue further. We may require one more lecture for because Sally says that here, tells here time is up. Then I will take up the next lecture next week probably. If you want to ask me a question, ask. I can continue for another 10-15 minutes if you all want. If you all are okay, let me know. I will complete this topic. Take a minute. I will complete this topic of primary evidence, the agreement of sale, how you produce it, and you prove it. Now, assuming for the sake of argument, you only have the copy of the document, the defendant has got the original. Registration करने के बाद defendant ने, the builder has not given you copy. उसमें क्या लिखेंगे आप? In the examination chief, in the affidavit, plaintiffs, I say that I have paid the consideration to the defendant pursuant to the agreement, entire consideration. The defendant and went for registration, defendant collected the document, promised to hand over the same to me, but he has not given to me. Only he has furnished me a Xerox copy, or he has not given me copy. I obtain a certified copy from the office of the registrar. I produce herewith the Xerox copy or certified copy. Under section 63 of the Evidence Act, the certified copy, a Xerox copy, is not a primary evidence. It is not the original. Section 63 देखेंगे तो आप. Then 63 का requirement ये कहता है, then if you want to prove this document, you will have to give a notice to the defendant under section 66 of the Evidence Act. placing on record that here I purchased the flat from you under this agreement of sale and I have paid you the full consideration. Agreement was registered and I came for registration. You were also over there, your representative. And the registration office was supposed to hand over the copy either to you or me within 15 days. You took the original receipt and you informed me that you will hand over the same to me. But you are not given to me. You furnished me a copy, or even a copy was not given to me. I have obtained certified copy. Now the matter is set on for trial in the wake of the fact that there is a breach of agreement. I have filed a suit for specific performance under Section 10 of the Specific Relief Act. I hereby call upon you to produce the original document in the court on the next date of hearing on so and so date till I am discharged as a witness. That is called notice to produce document under Section 66. Important again. This is how you can establish your document as a secondary evidence. If you don't give notice, the court will not admit your document. Now, once the documents have been filed by you as a plaintiff or defendant, the next step by the court exercises is this is also Section 165 and 166 of the Evidence Act. Sorry, 135 and 136. Under Section 135, the documents are produced. CPC के अंदर relevant provisions are also under Order 11 Rule 13 and Evidence Act के अंदर Section 135. Please note that. Then the court passes the order on admissibility of the document under Section 136. Mean the court will ask the defendant, you give your say. आप document को admit कर रहे हैं नहीं कर रहे हैं? Admissibility बोलते हैं. Oh, yeah, I am admitting the defendants. I am admitting. I am refusing. Mostly will say I am not. I do not admit. I do not admit. So this admission denial part is given both under the provisions of Order 13 and under the provisions of Section 136 of the Indian Evidence Act. Then the court passes the orders whether the document should be, whether it's the primary evidence to admit it, even the secondary evidence, whether foundation has been laid or not, it has to be admitted. Then if the document is not relevant, the court, if the suppose sufficient stamp duty is not paid on the document, court will order the document to be impounded. उसके लिए Order 13 check करो आप. CPC के अंदर power of the court to impound a document. Order 13 Rule 1 CPC के अंदर impounding. Court will say there are no registration charges, stamp duty insufficient. Send the document, confiscate the document, impound it, send it to the sub-registrar for the purpose of payment of the adequate fees with penalty and bring it back. The matter adjourned for 4 weeks time. Okay, this procedure you should know that this is both under the CPC Evidence Act and under the Registration Act, Indian Registration Act. You should keep in mind. So I will discuss it next time. All this provision. One more lecture we require on this point. We'll decide the timing. Anybody has any questions so far? Please ask me. We will continue this lecture on the next time. I do not want to bore you with so much time because you must be overburdened. बोलो कोई क्वेश्चन है अभी आपके पास? Anybody has any question? I will take it. Look like all of you understood. No questions.
Hello. Good evening.
Ji?
Sir, can I please under Section 10 of the CPC?
Amar, you are not audible.
You are not audible, Amar. Amar audible नहीं. जोर से बोलिए बेटा.
Lag हो रही है आवाज.
Your voice is breaking.
Am I audible now, sir?
Now audible. Now audible.
Am I audible now, sir?
Yes. Now I can hear
Okay.
you.
Good evening, sir.
Good evening.
Sir, can I take the plea of arrest sub judice under Section 10 of the CPC when order has already been passed in my
That is
favor
section-
earlier and now Section 10 of the CPC
That is a stay of
order
suit.
has
Section
been
10
passed by
deal with
the
stay of suit.
judicial body?
Section 10 deal with stay of suits.
Yes, sir. Yes, sir.
Yes.
So what
Now,
happens
stay
earlier?
of suit will not come into play at the time of the trial. That is an interlocutory application. At the time when suit is filed, you must take up
Okay.
the plea that in respect of the same cause of action, I have filed another earlier suit in Calcutta. The present suit be stayed.
Mm-hmm.
Yeah? So that is
Sir,
a that is a call a stage of
earlier,
an interlocutory stage.
so what if the elder brother of the same plaintiff in the present case has
Mm.
filed another case having same issues directly and substantially, which have already instituted before the quasi judicial body, and now they have come to the civil court?
Whether the court will decide whether the quasi judicial authority has the jurisdiction. Normally, title suits are filed only in civil court, not before the quasi judicial authority. They do not have right to decide title suits. Like consumer
There
court
is
cannot decide title suits.
okay. There is no issue
Arbitrator
of
cannot decide
jurisdiction.
title suit. Huh?
There is that matter falls under the jurisdiction of the Tahsildar only. There is no issue about the jurisdiction.
Again, Tahsildar cannot decide title. Tahsildar can only he can decide revenue authority whether
Yes, sir.
entries
That
are correct or not. Under the Maharashtra Land Revenue Code, he can only say entries are correct or not, whether he is
and
the heir
what
or not. But he cannot decide the fraud has taken place or not. Whether a party has right or not, Tahsildar has no jurisdiction. Only the civil court can decide under Section 9 of the Code of Civil Procedure.
and what if, like under Mamlatdar's Codes Act 1906, he has certain powers under Section 5 of that act, that
Yes.
if a particular road a particular person is using for quite some time, quite a few some years, and
Yes.
later on if that is obstructed, so in the favor of the plaintiff he passed the order, and by upon agreeing of that order, then defendant filed it in the civil court, uh, filed a declaration suit requesting the court to stay the execution of the order. So,
Yes. Yeah.
so,
Very good
so,
question. Very good question.
so can I take the plea of res sub judice, that is stay of the suit under Section 10
Again,
in this
Mamalatdar
present
courts
civil
are
code?
not civil courts. Mamalatdar courts are revenue authorities.
Yes, sir. Yes, sir.
They are revenue authorities, but their judgments are supposed to be not binding upon the civil court. Judgment of
Okay.
the civil court override the orders passed by the Mamalatdar court.
Okay, sir.
Civil
Okay.
court is a competent court under Section 9 CPC. It has got very wide jurisdiction. Whereas Mamalatdar court is passing orders under the Maharashtra Land Revenue Code touching
Mhm.
the entries and of the parties. It does not decide the title. Fraudulent aspect cannot be decided. Under the Easement Act, whether you have a right of way or not way cannot be decided. It can
Sir,
only
actually,
say that you are entitled to mutual. You're a tiller. You have been tilling the land. You are entitled to entries. You have been paying revenue charges. Merely payment of revenue charges that will not give you right title interest. Like
sir,
under the
my question is that that fellow now, he had challenged the order of the Tahsildar in the court of SDO, that is subdivisional officer, and
yes,
simultaneously he has come to the court of civil court for passing for a temporary and permanent injunction.
because civil court will decide whether you have right title interest. Civil court has a right to decide, frame an issue with regard to whether they, because while passing an order of injunction, the court will take into consideration three cardinal principles. Number one, prima facie case.
Yes, sir.
Prima facie case. Number two, balance of convenience,
Yes,
irreparable
sir.
loss. Huh?
Yes, sir.
So
Yes,
prima
sir.
facie case can there the court will say who has got a better right title, whether you have a better title or defendant.
Already order has been passed by the Tahsildar, no?
Tahsildar's order is relating to the land revenue code and the entries. But a
It is
civil,
not about entries in the
yeah,
present case, sir.
yeah, the easementary rights and the
Yes, sir.
easementary
Yes,
rights.
sir. Yes, sir.
But
Yes, sir.
according to me, Tahsildar cannot pass orders relating to easementary rights. You have to go to civil court.
Under Section 5, he has right to pass such orders for removal of obstruction if defendant has created any obstruction wherever that plaintiff was using that road for 10 years, 20 years in the past. So he has in the like nature passed the order, and that order has been order is now challenged by the defendant in the civil courts and simultaneously in the court of the subdivisional officer. So
Yeah.
what my question is actually, can I take the plea of res sub judice, that is stay of suit, in the
No,
court, in
because
the
it is
civil
not a
court?
competent court. It is not a competent court. Res
Okay, sir.
judicata plea can only be raised provided the issue is being tried by a competent court. Underline the word competent court. Section 11 में
Okay.
जाइए आप, underline the word
Mhm.
competent court having jurisdiction.
Okay, sir.
Not
Okay.
because merely suit is pending is not sufficient. If it is pending in a court having no jurisdiction, res judicata is not applicable.
No, res sub judice, sir.
No, it
Stay
is
of
yeah.
suit.
Even rest stay of suit is it is actually is applicable in respect of two different cause of one cause of action, one cause of action pending in two different courts. Under a
Yes, sir. It is the
contract,
case.
under a contract, suppose that you are in Delhi, I am in Mumbai. There is a breach of
Mhm.
contract under which I am liable to pay you 1 lakh, but I claim that under the contract you are liable to pay me 2 lakhs. So if I have
Mhm.
filed a suit earlier, suit in Bombay, you had filed a suit earlier in Delhi, I cannot file a suit in Bombay. You will say that already a suit is pending in Bombay in a competent court in a Delhi. But whereas proceedings between a Mamalatdar proceeding under the Maharashtra Land Revenue Code cannot be equated with the proceeding under the civil code.
Okay,
They are
sir.
two different proceedings. Civil
Okay,
court
sir.
proceedings are totally different.
Okay. So
Okay.
means civil court simultaneously can proceed with the matter
Yes. Civil court
even
can
if
decide your right title interest.
even if the matter is pending before the subdivisional.
Yes, yes. Subdivisional magistrate is only a tribunal. He is not a civil court.
Okay, sir.
Tribunal has got lesser power than the civil court. Civil court is supreme. Civil court passes, orders relating to right title interest. The orders of civil court will override the orders of the tribunal.
Okay, sir. Thank you. Thank you, sir.
Okay.
Thank you so much.
Okay.
Very good.
Okay. Good question you raise. Anybody has any more question? Chalo, happy Diwali to everybody. We'll wind up for the day. Huh? So next lecture will continue CPC only because this is a lengthy trial. Since we have come halfway, we'll try to finish it next time. Okay. Shall we wind up? Anybody has any more question? Professor Chabria has any question? नहीं.
Please.
Good evening, everybody. आवाज सुन नहीं पा रहे हैं हम आपकी. चाबरिया मैडम की आवाज सुन नहीं पा रहे हैं.
Thank you so much, sir.
Thank you. Wish you happy Diwali. You and all of you, all the participants. Okay, looking forward to see you next week. Okay, Baba, good night.
Thank you, sir. Happy Diwali.